Hello and welcome to the Sustainable Materials Management Webinar Series, a joint effort between the National Recycling Coalition and the Pennsylvania Recycling Market Center. My name is Wayne Bowen. I'm the Program Manager for the Recycling Market Center and will serve as your moderator today. Today's topic is titled Environmental Justice Issues for Recycling Facilities, and our presenters today are Michael Trupin and Eli Brill, who I will introduce in a moment. After their presentations, we will have a Q&A session. So if you have a question or comment, you can use the Q&A feature located on your control panel on your screen. Please note that an edited version of the webinar recording will be made available for viewing via YouTube links on the National Recycling Coalition and Pennsylvania Recycling Market Center websites. And also please note that Pennsylvania Recycling Market Center, its affiliates and funders, and the National Recycling Coalition assume no liability resulting from the use of any information provided during the webinar. The webinar is provided only as an informational tool, and no discrimination is intended and no endorsement by these organizations is applied. And so our first presenter is Michael Trupin. He has 26 years of experience in addressing complex environmental permitting, environmental justice, compliance, and sustainability matters. The majority of his environmental skills and experience are focused in air quality, permitting and avoidance, best available control technology analysis, risk assessment, agency interaction, and regulatory analysis. He currently serves as Director of Air Programs for Sims Metal. He previously managed Trinity Consultants, New Jersey and New York office operations. Prior to joining Trinity, Michael served as the Facility Manager of the Ocean County MRF for Waste Management, as Waste Management East Group Director of Environmental Protection and the East Group Director of Air Programs. From an industry perspective, his work has focused on metal and auto shredders, landfills, gas to energy facilities, electric generating units, wastewater treatment plants, and various other source types. And I'll turn over to Michael.
Thank you very much. Just to confirm, Wade, you can hear me okay?
Yep.
Excellent. All right. Well, thank you very much. I appreciate the opportunity to be talking to folks about a subject that is near and dear to my heart, New Jersey's environmental justice rules. And I know we have a lot of folks from across the country on the call today. And while the focus of my talk will be on New Jersey environmental justice, Eli's going to expand on beyond New Jersey. But while the focus for myself is on New Jersey, I do want to qualify that there's a reason for that. And the reason for that is that there is a tremendous amount of national attention on New Jersey's environmental justice rules, the process in which they came to these rules, and now as of the middle of April, implementation and the effectiveness of those rules moving forward. So thought it would be good to discuss with folks what we're seeing in New Jersey from a regulatory perspective right now on EJ, what some of the key terms are and concepts are, and we'll go from there. Just a first general disclaimer. Obviously, you can all read through that disclaimer. Ultimately, these are my views, not the views of the organization that I work for, Sims Metal. These are definitely controversial topics that we're discussing today, and these statements that I make and that Eli makes following me up cannot be relied upon for legal or consulting advice. And so today we're going to go through a few things, but again, the focus really is New Jersey's environmental justice rule. Going to have a very brief history of that rule itself, not too much. We're going to discuss key terms and definitions. I think that's very important as folks start to work with environmental justice moving forward to understand what's going on from this regulatory perspective. We'll look a little bit at EJ Map, and that's New Jersey's mapping tool for environmental justice and for urban communities. And we'll also look at how, we'll spend a little bit of time talking about how stressors are looked at within the state of New Jersey, and within those rules. And then we'll just summarize the rule a little bit from a process perspective and a little bit of commentary on that. So from an environmental justice perspective, as far as the definition is concerned, I'll take a second just to read the top definition, because I think it is important. So while this is on DEP's, New Jersey DEP's website, this is an EPA, US EPA definition. environmental justice is the fair treatment, meaningful involvement of all people, regardless of race, color, national origin, or income, with respect to the development, implementation, and enforcement of environmental laws, regulations, and policies. And so it is an important definition, without a doubt. Fair treatment, basically meaning that no one people should really bear the disproportionate share of consequences from industrial activities. That's the fair treatment piece, and then the meaningful involvement piece. And we'll talk a little bit about this on a few separate occasions. But that meaningful involvement really being that the opportunity for the community, the public, to participate in decisions about their environment and about their health. And so that's what this comes down to. New Jersey would tell you that historically, low-income communities and communities of color have been subject to a disproportionately high number of environmental and public health stressors. And so this is on a national level as well, but in a state perspective, this is definitely what that is about. It's about that disproportionately high number of stressors to certain communities. I said that I would do a very brief review of the history of the situation, and so I will keep it extremely brief. We've had ultimately a 3-year process in New Jersey, but I will qualify that there was some form of EJ policy in New Jersey prior to this 3-year period. But ultimately, we've been going through this for 3 years, starting in January 2020 when the bill was introduced. But most importantly for folks in New Jersey, it was in September of 2021 where we had an EJ administrative order that was put into effect. And so essentially, New Jersey has been living with some form of EJ rule, policy, whatever you might want to call it, order since September of 2021. And so we've been going through kind of maybe not the entire nuts and bolts of the regulation, but we've been living with aspects of the regulation since 2021, and that does include a more a broadened public meeting concept that we've been living with again since September 2021. We just didn't have impact statements, and I'm going to discuss what all that means in a couple of minutes. And so from this year, from April 17th, so a little over a month ago, the rule became effective. The EJ rule became effective, and it's been off to the races since then, with many folks across the country very interested in what this means to them. The purpose of the EJ rule is actually spelled out within the rule itself. Again, this concept of meaningful public participation. Really from a new facility perspective, we're going to talk about that a few times, but from a new facility perspective, they want to make sure that no new facilities are placed in the location where they would create a disproportionate impact. And we'll talk about what those terms mean. And really, this is about reducing environmental and public health stressors. Those are the key concepts from a purpose perspective for these rules. I'm starting to see that each state and even the federal government has a different concept of what overburdened community is. And so, as far as New Jersey's regulation is concerned, it's from a low-income perspective, at least 35% of the households. From a minority perspective, at least 40% of households, and this is an or, it's not an and, or at least from an English proficiency perspective, and this is one that differs, I think, with on the federal level. Someone like Eli could probably touch on that better than myself, but there's from an English proficiency, the number is at least 40%, and so if we're above that, we'd be considered an overburdened community. The concepts of limited English proficiency and low income, they are spelled out within the rule, and ultimately the data for these comes from the U.S. Census Bureau. So what that looks like, I know this is probably not the easiest thing to see on your screen, so I apologize, but ultimately if you can see my mouse on the screen, possibly, you really see from New York down to essentially through Trenton and Philadelphia, this kind of very large area of what would be considered overburdened communities. You can see that bluish color is the overburdened communities. And then there's a few other a few other locations as well beyond that. I think I have a stat somewhere a little bit further in that talks about just how much of the state this is concerned. But if you take a look, it's certainly not a small amount of the state from an area perspective. Here's just a close up. This is from New Jersey DEP's EJ map. There's a lot of mapping software now, depending if you're looking at the US EPA or California or I think various other states. But New Jersey has a very robust mapping tools for EJ purposes. We're going to talk about what stressor summaries mean, but you get stressor summaries, you can look up facilities, you can look up the overburdened communities, and even get metrics on those overburdened communities. But this is just a zoom in of one particular facility in the Trenton area, and just intended to show you what the OBCs look like, the overburdened communities look like from a close-up perspective. Again, these are just ultimately block groups. And so I've used the term stressor a few times, and that is it's a critical aspect of New Jersey and actually any states and federal government, any state's regulation as it relates to environmental justice. And so these stressors are ultimately a variety of items that impact either the environment or impact can impact, I should say, people's health. And so New Jersey, I believe as we go through this, you're going to see 29 different stressors that were selected by New Jersey. Not only will you see those 29 stressors, but in this, you'll also see the source of the data that New Jersey is utilizing to evaluate each of those stressors. And so this, as you can imagine, this is a massive accounting undertaking to evaluate these metrics and make sure that you're getting the proper data, make sure that the data represents what it should represent. And so I won't get into an in-depth discussion on those things, but there's concern, and it's a lot of information, and it's a lot of information being used for very important purposes. And so it's important that we get this right. But what I'm talking to you about right now is the current state of things from a stressor perspective in New Jersey. I will not read to you all the stressors, but you get the idea. The first on this page are related to air pollution. And there's the stressor and then the source of data that they utilize to evaluate the stressor. And that goes on. Like I said, there's 29 of them. So here's the mobile source category. Stressors, I should say. Here for contaminated sites, that's another group, the next grouping of different stressors. After that, just the presence of a solid waste facility or the presence of a scrap metal facility, and solid waste actually includes solid waste, other solid waste, and recycling facilities. Just the presence of these is a stressor. And so the way it's evaluated is for a particular community, particular block group, it's the sites per square mile, the number of solid waste sites, or the number of scrap sites per square mile. And so right from the get-go, proposing any recycling facility or any scrap facility kind of checks the box of adding another stressor to our totals. And I'm going to show you what that means in a second. But it's extremely limiting from a perspective of how do we continue to advance recycling? How do we continue to grow as an industry and see the benefits and rewards of recycling? Right now, something like this, it represents a little bit of a concerning challenge to moving forward. So we'll talk about that. Some additional sources, stressors for the water pollution side. Here are potential public health stressors. Those are listed here with the data sources associated with them. And I think lastly is density, or really just the amount how folks are packed together, how everything in a given community is packed together tightly. Here again are some of those stressors, and then finally for social determinants. So those are the stressors that we're looking at within the site. So what the state does is they look at each of these stressors and they compare them to a geographic point of comparison. And I'm going to show you what that looks like on a cumulative perspective. But ultimately, for each stressor in a given overburdened community, they compare that stressor's value to the value associated with the 50th percentile for either the state or the county. They take the lower of the 50th percentile for that particular stressor from the state or the county, and that determines whether or not you have an adverse stressor. So the stressors, then you compare the stressor to the geographic point of comparison. So that's a state or county 50th percentile. And that determines for each stressor at a site whether or not you have an adverse stressor. I'm going to show you some information to kind of help that get into your heads a little bit. These are the geographic points of comparison. These are the stressor summaries. So what they do is you get a score for your entire. I'm going to show you the score sheet in a few, but you get a score for your entire overburden community, and that score is compared to either your county 50th percent cumulative score or your state 50th percentile cumulative score. And so you could see here, you take the lower of the two. So if I'm trying to put a facility in Mercer County, let's bad example because of the same numbers. If I'm trying to put a facility in Hudson County and my county 50th percentile for the OBC is 17 and the state OBC 50th percentile is 13, then I have to compare my site to 13. And so what that means is when I add up the number of adverse stressors in my particular overburden community, if the number, remember we had 29 total, I think they evaluate 26. If the number of stressors that are adverse or higher than the 50th percentile is greater than 13, then my overburden community would be considered, it would have disproportionate risk. It would have an adverse total of stressors. And that's how the comparison goes. And then we have, depending on whether or not we're adverse, there's more things that we need to do in the state. So there's quite a bit of accounting that has to go on. I'm going to talk to you about what all that accounting means in a second. But it's a pretty extensive process from an accounting perspective. 85% of the overburden communities within New Jersey have adverse cumulative stressors. So those are the areas, 85% where if we're trying to, I'm going to show you what this means, but if we're trying to put a new facility up in 85% of those areas, we would have considerable roadblocks to putting a new facility in those locations. Also, it's important to mention that overburden communities with adverse cumulative stressors, it's about 58% of the land area within the state. And so that, again, is concerning from a recycling standpoint because we want to make recycling as accessible as possible. Let's move on. We've talked about this concept of adverse cumulative stressors, and again, it's you add up for each of the stressors the total of the overburden communities if it's higher than the geographic point of comparison. So that would be 1. If my stressor total for the overburden community is higher than the geographic point of comparison, that's 1. And then we add it up for each of those situations, for each of the stressors, and you can get, I think, as high as 26 as far as the total cumulative stressor total is concerned. An adverse stressor or an adverse environmental and public stressor is just what it sounds like. It's higher than the geographic point of comparison. And then this concept of compelling public interest, I'm going to talk about on the next slide. So basically, if we have a new facility that is located in an overburdened community, and that overburdened community has adverse cumulative stressors, so my stressor total, that sum of adverse stressors, is higher than the geographic point of comparison, then my permit for that new facility, it's a new facility, would be denied unless I can show compelling public interest. And this is an extremely controversial subject from an industry perspective. Folks were looking to have some type of economic benefit incorporated into this determination of compelling public interest. As of right now, how the rules were finalized and written, there is no economic benefit considered within the concept of compelling public interest. And so it really comes along to what's exactly on the slide. Does the proposed new facility, is it going to serve an essential environmental, health, or safety need for the overburden community? Again, for the overburden community. This proposed new facility is it necessary to serve that environmental health and safety need of that community, and are there no reasonable alternatives? And so it's a difficult analysis to put together and to justify compelling public interest. I understand why it's difficult, but again, just a difficult thing to be able to demonstrate at this point in time. The concept of disproportionate impact for a facility, I mean, just really for a permitting action that you're going through, either you're creating adverse cumulative stressors or you're contributing to already adverse community stressors. So when you hear that term, disproportionate impact, that's all it means, is that the facility has had effectively a negative impact on the particular overburdened community. Existing facilities, those that possess a valid approved permit for its operation as of the effective date of the rule, so in April of this year. And expansion, it has been a controversial topic as well. A modification or expansion of operation of footprint that has the potential to result in an increase of the site's contribution to any stressor in an OBC. That's a tough one. And you could say that many of the administrative things you might do probably will not trip this expansion, but granted, many of the other things that you try to do at your facility, it's going to be difficult to demonstrate that you don't have any impact from an increased perspective on a stressor. As far as new facility, the important concept here with new facility, it's again, you have not commenced operation as of the effective date of the rule, or you change what your facility does, how your facility operates. But the big thing to keep in mind is in red here, and this is a difficult one. Existing facilities that have operated without a valid permit required by the department is considered a new facility. And so the difficult part of that is obviously if you're in non-compliance. Non-compliance is is a critical aspect here. But the big thing here is if the department changes its policies, its interpretations, the way it views certain aspects of its regulation, and all of a sudden determines that you need a permit for something that was never really considered necessary previously, that creates a difficult situation where you're effectively calling an existing facility a new one. And so again, there's some concerns there from a standpoint of how this all works and how this all gets put together. Recycling facility, I'm not gonna, excuse me, one second. I went ahead of myself. From an EJ rule facility, so what facilities are we talking about? Who needs to care about this rule in New Jersey? The first is major source facility. So any Title V facility needs to care about this and has to live through this. Resource recovery facilities. I'm not going to read them all to you, but in general, the ones that we care most about right this second for the intent of this call. Transfer stations or other solid waste facilities or recycling facilities that receive over 100 tons per day, and near and dear to my heart, scrap metal facilities. So it's difficult. I mean, this regulation is very much focused on the waste industry, but also on recycling, and so sometimes recycling gets lumped in with waste as its near cousin. And so our concern at this point is just making sure that there's no impediment to continued growth of the recycling industry. And so we want to be careful with how we view and categorize recycling facilities. With that said, recycling, I'm not going to read the definition of recycling facilities and recyclable materials to everybody, but that is called out within the regulation. It does point to the recycling regulations within New Jersey. Scrap metal facilities are called out as well and defined. One concerning aspect, scrap metal facilities, it indicates that they do include scrap or junk yards. So it's not just processing and shredders and things along those lines. It's actually just including yards that simply accept and then turn around and send to recyclers various types of ferrous and non-ferrous materials. And so again, a little concerning from a rule perspective and how things are laid out. We're trying to work within that construct right now and figure out exactly what this all means to us and other recycling facilities. Keep in mind everything I'm about to say, that we want to remember the applicable facility types. There's those 8 types of facilities that I read to you, or that we took a look at. That's the kind of the first piece from an applicability perspective for this rule. So you go through application submittal. So you need an application submittal either for a new or expanded facility. These are your regular applications for anything you might be doing from a permitting perspective. Your applicable applications for sites located proposed to be located in OBC. So basically, no decisions are going to be made until you go forward with these EJ rules, and you document compliance with these EJ rules. Only the applications that have been deemed complete for review will continue on within the process. And the DEP is going to look at these rules, at these overburdened communities every 2 years. They're going to evaluate which communities are considered overburdened communities. From a procedures perspective, I think, Eli, I got 6 minutes, and then I'm going to hand over to you. From a procedures perspective, DEP is going to provide an initial screening, and I'm going to show you what that looks like on the next slide. It's going to have the stressors, your geographic points of comparison, and so on and so forth. Then after, if you are, in fact, if it's necessary, if you're an adverse community, overburdened community, you will move forward with an EJ impact statement. I'm going to show you a little bit what that means. And then you have submittal of your EJIS, and then you have to have public participation thereafter. And so from a kind of a scorecard perspective, this is what the DEP is going to provide. I have a feeling that many states are going to start to see similar types of information and programs going forward. So here's there's another page I'll show you, but here's all the stressors that we were talking about on the last slide, or excuse me, a few slides ago. And so what they do is they get a value for each stressor. They go through and look at the metrics that were on that previous slide that I showed you. They get a value for that stressor associated with the block group that your facility is within. They compare that value to the county and the state 50th percentile version. And when they look at that 50th percentile, it doesn't include overburdened communities. They take that out when they evaluate 50th percentile. They take the lower of that state or county number, they compare it to your block group number. And if your block group number is over that, well, then you have an adverse stressor. And so all they do is they go through and they add up, again, there's a second page here, so you can see. They add up all of the adverse stressors, and that becomes the score. That's the 23. That's your combined stressor total for your particular area. For your particular block group. They compare that stressor total to 13, which is the geographic point of comparison for either the county or the state. It was the lowest of those two. And so since 23 is higher than 13, we're higher than the 50th percentile. And this location would be considered having an adverse cumulative toll of stressors for this particular location. And let's see what that means to us. So facilities that are not subject to adverse cumulative stressors, they would have a limited EJIS. So if you're in an overburdened community, but you're not subject to adverse community stressors, and the facility is not going to cause a disproportionate impact, the facility is not going to make the community go adverse, then it's a limited EJIS. I'm going to talk about what that means. If you do have disproportionate impact because of your facility's activities, or the community is adverse, then you have a more extensive EJIS that you need to do. So keep in mind that either way, if you are in an overburdened community, you are going through some form of EJIS. So the limited EJIS is really not too bad. A lot of this information you probably provide in your typical permits, whether it's an air permit, a solid waste permit, or whatever it may be. And the biggest thing I'd say is public participation plan, but we're already doing that in New Jersey under our administrative orders. So there's some troubling stuff on here, but really not too scary. The bigger issue is if you do have this disproportionate impact caused by your facility. I'm not going to read these all to you, but this is the supplemental information that needs to go into your EJIS, your impact statement, Some concerning things like a NACS comparison, a traffic study, design and siting alternatives. Some of these things are on the order of possibly $100,000-$200,000 in total effort to put together some of these reports. This is a massive cost to the facility. And one concept is maybe you do this early and you keep putting together parts each year, so you have it on file. I'm not sure I necessarily have the answer to it yet, but again, a little concerning. The concept of meaningful public participation. 60 days prior to your public hearing, you have to be, you put out a notice to the municipalities, you post in newspapers, so on and so forth, certified mail notices to all residents within 200 feet. And these are major efforts. And then your comment period has to remain open at least 30 days after the public hearing. And you have to provide a transcript and public responses to public comment to the DEP from there. I'm not going to leave off this slide right now in the interest of time. I think I got about 60 seconds. Some of the interesting aspects, if the EJ chapter and another DEP chapter, if they conflict, the EJ chapter supersedes. General permits and similar do not get considered within the EJ regulation. So if your activity requires a general permit, you're in good hands. You could pretty much not move forward with the EJ aspect. But it does apply to most or many of the regulatory programs. I won't read the whole list of those. There were a few concepts that I didn't discuss today, like localized impact control technology. I won't get into that, or Title V renewals. If the DEP needs experts to review what you put together, because of the nature of the information you put together, they will invoice you for bringing in that consultant, that expert to review on their behalf. And like I said, more than half of the municipalities now contain overburdened communities. I've hit my time limit. I have 2 slides, Eli, and then I'll be done. As far as DEP's consideration is concerned, if there is no disproportionate impact from a stressor's perspective, you can proceed, especially with any conditions needed to avoid that impact. If there is disproportionate impact, again, you have these adverse cumulative stressors. New sites, that application can be denied unless you have compelling public interest. Expanding sites, you're going to have conditions in your permit to minimize the impact of your site. And then even Title V renewals, you will wind up getting authorization to continue to move forward, but it will have conditions. Last 2 more slides. I think we're in good shape here. Existing and proposed. I think we can. Yeah, it's a 3-part test is what we've been talking about. What are you in an overburdened community? What type of facility are you? And what type of application are you submitting? Those are the key aspects of the 3-part test. And last, but certainly not least, again, more time. I think we're good. We're good with these. I think the big thing is, like I said on the bottom here, listen to your community, understand and engage that community. This is all a massive cost. This is a huge effort, but work with your community, be transparent to your community, and I think a lot of what we have here will be easier and easier as time goes forward. Thank you very much.
All right, thank you, Michael. As I said before, we're going to hold our questions to the end. I do have some questions on already, but we're going to wait. I know I have some questions, so we're going to wait till the end. And while I'm reading Eli's bio, he's going to bring up his presentation here. So Eli Brill is an attorney at Land, Air, Water Legal Solutions, LLC, located in Berwyn, Pennsylvania. Prior to law, he was senior legal counsel at Waste Management, where he focused on air and solid waste issues. Eli has over 30 years of legal experience representing and counseling clients on environmental permitting, transactions, project development, compliance, enforcement matters, public participation in rulemaking and policy development. For 20 years, he has served on Pennsylvania's DEP Environmental Justice Work Group, followed by its Environmental Justice Advisory Board. Eli also has served for the last 9 years on PADEP's Solid Waste Advisory Committee. Representative clients on environmental justice issues include incinerators, landfills, cement recycling facilities, waste to fuel projects, alternative energy facilities, and remedial construction contractors. And so I'm going to turn the program over to Eli.
Thank you. Can you guys hear me?
Yes.
Awesome. I will flip through these slides in Bob Dylan style, like one of his videos where he had the flashcards. In the interest of time, I have way too many slides than I can review. And I have the same disclaimer as Mike Trupin. You cannot sue me for giving legal or consulting advice. And these are my personal views, not the views of Land, Air, Water Legal Solutions. I'm going to skip over the definition of environmental justice, but my introduction slide, Mike covered that. I will be talking about the importance of environmental justice in the recycling industry. I have some ideas on how to incorporate EJ into sustainability, and I'm really going to try to have a laser focus on anaerobic digesters and biogas as an example of a potential context when it arises, because I think it's going to be a big deal, and I'm seeing some EJ complaints in this area already. I previously asked questions on this subject as a DEP, Pennsylvania DEP Solid Waste Advisory Committee member in the context of food waste, which is why I think I've been asked to do some of these EJ presentations. Mike already reviewed the background to environmental justice, and I really don't have time to get into sort of the whole social history background of it, but I will mention, as you can see from Mike's presentation, that cumulative impacts is becoming huge. Climate justice is another area where you see development in EJ since 2010, and this ESG movement among investors to look at environmental, social, and governance issues. It intersects with EJ. So now we're talking about looking at not just nearby residents, but your whole supply chain and the whole waste and material management cycle, which becomes relevant to food waste. I'm going to skip history, except to say that this whole issue of what you're going to consider in EJ and the extent to which race minority can specifically be considered, that's probably going to be the subject, not probably, that will be the subject of a Supreme Court case, I would assume by the end of June. And a lot of the states that are relying on race as a criteria for deciding who's an overburdened community may have trouble as a result of these college admission cases. And so stay tuned on that. For example, President Biden's Justice 40 tool does not rely on race. I don't think the California MAPR program relies on race. So it'll be interesting to see how that shakes out. On the subject of what's the federal law of environmental justice, it's a confusing substance and there really isn't law. You've got protections against discrimination, but that, and you have public process, the meaningful involvement, but that piece of the definition Mike discussed, the fair treatment, this idea that environmental benefits and burdens should be distributed fairly or equitably among groups, that doesn't really have a strong basis in the law. There's an argument that under Title VI, that states can, the federal agency and through their grant funding, the states, that they can enforce that. But the original law of EJ and civil rights was Title VI and a prohibition against intentional discrimination, which has been notoriously hard to prove. This slide reviews a series of executive orders, going through President Clinton from 1994 and through at least 3 executive orders that President Biden issued, one as recently as last month, reaffirming our commitment to EJ and, creating more infrastructure for that and more, funded groups to administer this. But it's a super priority of the Biden administration, and facilities, in addition to facing these new federal programs and these state laws, they're seeing threats of enforcement by EPA and overfiling on environmental justice grounds, even if the law isn't completely solid. I'll go to the next slide and just say, I will try very briefly to go over other state measures, but this is the webpage on the National Conference of State Legislatures that covers every type of state and federal effort on environmental justice. I definitely recommend it as a resource. The only state that I've seen that's gone as far as New Jersey is New York. On New Year's Eve, the governor of New York signed into law a new law that will require, I think at the end of this month, equitable siting of facilities, and they will require environmental impact statements to see whether or not you're causing a disproportionate burden on disadvantaged communities. I don't think I'll have time, but there's slides at the end that go through some of the aspects of the New York law. And basically, under their environmental assessment law, SECRA, if you have a SECRA review, you now have to have an EJ review. And it talks about having background monitoring data. And it doesn't even have the loopholes that New Jersey has for compelling state interest. Maryland's also using an EJ scoring technique that I think goes to recycling facilities and definitely goes to concentrated animal farming operations. The history of recycling plants and EJ issues is actually greater than I realized, despite being in this field for 25 years. I recently read David Pelham's Garbage Wars about the Chicago recycling situation in the 1980s, probably through the early 2000s. And I definitely recommend that book as a read. There's also a lot of EPA rulemaking on the definition of solid waste. And in the hazardous waste recycling context, they look at cases where those facilities caused harm. They did a demographic analysis in the context of trying to make things like pellet fuel out of secondary solid waste. They looked at this issue and they established a legitimacy test for recycling that really requires careful operations. There were a lot of damage cases under the Superfund law, CERCLA, for battery cracking facilities. So just because recycling seems environmentally beneficial, we shouldn't assume it's not a big potential issue in the EJ field. It has been the focus. Basically, this slide reflects that every type of plant that we would call a recycling plant has generated opposition with environmental justice claims. In addition to it, once again, I said I'm very interested in anaerobic digestion, which produces a methane biogas that is typically combusted to generate electricity or put into a pipeline or used locally for vehicle fuel. So in addition to community and EJ advocates having issues with recycling facilities, they have a lot of issues with what we'll call renewable energy technologies. And every type of renewable energy technology has been the subject of an EJ claim. Biogas and biomethane, when you sort of turn biogas into a substitute for pure natural gas, those are controversial. But even wind projects have been challenged by indigenous tribes in Mexico and solar facilities up in Silicon Valley. So no one's immune from these community-based claims. I'm very interested in the issue of food waste and environmental justice, and particularly how Pennsylvania's handling it and some of the federal programs. You see this weird dichotomy where the government's very interested in environmental justice, but they're trying to push food waste. And while the normal waste hierarchy is to first reuse it where it can be as food, and then maybe use it as animal feed or something else, before it goes to a waste to energy facility or ultimately to a landfill. They're talking about industrial use by turning food waste, at least commercial food waste or industrial institutional food waste, to kind of be co-digested with anaerobic digesters. And I saw and by contrast, the EJ advocates are not in favor of these anaerobic digesters, even though they purport to be good for climate change, because the underlying source is agriculture. They're against factory farms and CAFO. those are considered EJ, and there's research about whether they're disproportionately located in minority and low-income communities, and there's research about whether they cause health effects. We can argue about whether the studies are mixed or not, but it's a clear area where I would expect EJ claims. And I was also curious about the issue about whether shifting food waste from landfills to waste to energy, whether it's an anaerobic digester at a farm or at a wastewater treatment plant, would disproportionately impact communities of color or low-income communities. And I was also interested in some of the GHG benefits that were being stated, in this case by DEP, because landfills themselves are very minor emission sources in the state greenhouse gas budget, only 0.35%. And the latest air toxic regulatory rulemaking showed they're not disproportionately located in minority or poor neighborhoods. So, and a lot of landfills most of them have these landfill gas to energy projects. So it didn't seem like the incremental benefit from an anaerobic digester would really make sense. So DEP presented these issues in December of 2021 in front of the Solid Waste Advisory Committee. They were talking about diversion of large sources of food waste over a ton a week. And I'll kind of jump ahead, but they were ultimately recommending among the existing facilities, maybe we should add 7 new ones at $3 million a piece and get to add another 7 facilities that'll handle 77,000 tons of food waste a year. So this is the slide that shows the food waste presentation. There was no EJ analysis. They gave a slide of where these digesters are currently processing ICI food waste in Pennsylvania, sewer plants, on-farm digesters, and standalone facilities. They showed where compost facilities were processing ICI food waste, and they made this proposal to upgrade with 7 facilities, noting that there's another 83 facilities out there that aren't currently processing food waste. And all they said about EJ was, let's establish a grant fund for food waste to energy infrastructure for existing and new facilities, and let's emphasize environmental justice communities. I didn't know what that meant, but if it meant locating the actual facilities and the pipelines or the combustors of the gas into the EJ community, maybe they don't want them. So has there been discussion? So I asked these questions. I asked them again at a 2022 meeting when it came up again, or at a SWANA conference in September of 2022, and I still wasn't getting answers. So for this presentation, I decided to make an effort to find the answers. I went into EJ Screen and I searched the Geo platform and loaded EPA's current data for anaerobic digesters. And here I show you the dairy digesters in red, the swine digesters. There's 3 of them in green, and there's one big green gray circle at the bottom right. That's a mixed use one. And most of them are small. And I then overlaid EJ Screen for people of color. I also overlaid it for low income. I did not see any association with these sites with people of color. With low income, I didn't either, but I was starting to get some dots near 60 to 80 percentile sort of numbers, and EPA sort of triggers off if you're in the 80th percentile or worse for a particular category, maybe we'll consider that environmental justice. So I started with the socioeconomic indicators, which is the traditional way of doing it. I then did a similar measure where I loaded into EJ Screen using Search Geo platform, the Department of Environmental Protection's test, which doesn't use this 80th percentile test. I was on the work group, which over 23 years ago came up with the test of, is a census unit, it was track groups originally, greater than 30% minority or 20% individual poverty. On this map, I'm showing the latest version that DEP wants to use, which is 2015 block groups. And they actually add a half-mile circle or buffer around each block group. This just shows the block groups without the half-mile buffer. And I started to see some, at least under DEP's test, getting closer in Lancaster and some other regions where maybe they'll bump into an EJ area. DEP is currently amending their policy, and they may broaden it to include things that Michael reviewed before, like linguistic ability or education, all of the supplemental indexes, maybe age under 5 or age over 64. Those are the classic ones. Unemployment's another big one that's typically being used as a supplemental index. I tried to find other stuff about where these anaerobic digesters are located and whether they're in EJ areas. I started to focus on the wastewater treatment plants. The only good database you can find at first is by Water Environmental Federation. EPA refers to this database. It only covers facilities over 1 million gallons per day, but you can start sort of winnowing it down to things like, is the biogas put into for electricity? Does it go into a pipeline? Is it flared? So just to show you an example, these are the only sites that are showing up for pipeline injection, probably going to the California low carbon fuel market, which rewards biogas facilities throughout the country very favorably economically. So I wasn't pleased with the WEF database. It was too hard to use. I went into the air toxic rules for wastewater treatment plants, publicly owned treatment works, and I saw that under their analysis, it's higher on minority, higher on low education, and on poverty and linguistic isolation. African-American, it was twice as high than what you would have expected based at least on the national rate, assuming that's a good point of comparison. But there were no cancer risks above 1 in a million. But this kind of data kept me interested. What I eventually found that I thought was the good data source is EPA's Clean Markets Division has this thing called eGrid, which shows you every power source over 1 megawatt that goes into the grid, or virtually everyone. I selected other biogas. That's not regular biomass, but just other biogas. And I got a list of 74 facilities. And on tab 21, they actually have demographic information that matches up to EJ screen. So I stuck in on yellow highlighting any facility where any of the indices for race, for low income, for age, for educational attainment was over 80, and I highlighted them. And then I did manual counts. This is the second page of them. And what I found was that if these facilities were distributed randomly, you would expect, a fifth of, 20% of them to be in the 80th percentile or higher. And the distribution of facilities seemed to match that, particularly for race and for low income, much less than I would have expected for age, higher than I would have expected somewhat for limited English or less than high school education. What's interesting, though, is if only one of those factors is necessary to trigger EJ, then, probably half of them trigger an EJ review. And right now, we're not using all those supplemental indices, but they're becoming used more by the states and by EPA. And I think they will be by Pennsylvania. I have a lot of biases, and one of my biases is that municipal waste combustors have to be in EJ areas. And I grew up in Pennsylvania. All I've ever heard about is that Chester, PA is like the worst or the second worst example of EJ in the country. And I like to take pot shots at the municipal waste combustor industry, even though I used to represent them a long time ago. So I looked up Covanta, the Chester plant. I keep hearing EJ allegations from Chester for the last 30 years. It's not showing up as EJ. The demographics index is only at the 53rd percentile. It's average. It's average on low income. It's at the 58th percentile. I'm sorry, I'm reading percentages. It's at the 71st percentile. It's close, but it's not as heavily EJ as it's always been stated. And on this map that was released by the Energy Department and by EPA, probably in the last year, it is not showing the Chester plant as EJ. So these plants produce all kinds of different results depending on which map you use and what's going on. So getting back to anaerobic digesters, you're going to see this stuff come up in 3 contexts. One is in regulations. I'm seeing environmental groups objecting to the generation of credits for turning biogas into electricity that can be used for vehicle fuel. They're very rewarding credits under the federal RFS program for vehicle fuel. They give these credits called RINs, and California gives these low carbon credits. I see environmental groups saying biogas is an EJ issue and don't allow those E-RINs. Anytime a grant is being given, and there's big grants being proposed or that have been enacted for things like anaerobic digesters under the bipartisan infrastructure law and the Inflation Reduction Act, there's going to be something required that's either going to be a little environmental policy act type analysis or a big one where you're going to have to show there's not an adverse disproportionate impact on minorities or low income. In the context of permitting expansions and renewals, citizens are going to complain even where there's not, or environmental groups, even where there's not a state environmental justice law or something with great teeth. They're going to be making discrimination claims under Title VI, and we've seen this in the environmental justice context for anaerobic digesters in Delaware. I'll review that case very briefly and show you some quick maps. And I expect more requests for ATSDR health consultations. The big case that I saw that came out recently is in Seaford, Delaware, where a Title VI complaint was filed by the NAACP and probably 10 or 20 or more environmental groups, ACLU, and a local group about a proposed poultry waste biogas facility where there was an existing composting poultry waste facility, very large volume facility. I think it's 200,000 tons per year. And the claims of the EJ plaintiffs, and it's a very long document, are in essence, we don't like this facility. It has EJ impacts, but we've got you on procedural EJ. You fail to translate materials. You fail to do sufficient outreach with a Haitian Creole-speaking population. And there's disproportionate impacts due to the lack of notice and public participation. You haven't given us the cumulative burdens. There's 199 vehicle trips a day. There's going to be a pipeline. You're going to truck renewable natural gas. You need to do a do-over. So that's pending before EPA. I did some EJ screens of the area because they didn't, in the EJ complaint, EPA was hiding the exhibits and some of the other information. But if you just type EnviroWay, Seaford, Delaware into EJ screen, you can find this facility instantly. And it wasn't really, I did a 2-mile circle, which you can set up in EJ screen. I looked and I saw on low income, probably within the 2-mile circle, the low income tract that they're referring to. And you can just toggle on this stuff and you can either look at socioeconomic features, you can look at hazard features of the sort that Mike referred to before, air indicators, proximity to different kinds of facilities, and some of the climate change data that's out there. And that data has severe limitations, but it's used to tell stories. So it's useful. And there's a toggle for Justice 40, which uses only socioeconomic criteria, not race. Very different results depending on what you use. There's 5 different mappers that cover this facility. Delaware DOT has a facility mapper that works differently than DENREX mapper, that works differently than EJ screen, that works differently than Justice 40, and that works differently than an ATSDR mapper. In the Delaware DOT mapper, they show 5 subtypes of mapping types that they could have done, each producing different results. Under Justice 40, that facility and that census tract is not disadvantaged. Under the block group method, it's not disadvantaged. Delaware came up with their numbers. They used something called MAPCO, which has its percentages based on race and poverty. And they said, you know what, it could have been worse. And it's, by the way, the Delaware method is okay for this facility, the DOT method. But then they said, you know, we could have been worse if you think we're being harsh. Under the Massachusetts method, it's worse. And the Seaford facility, this AD facility, would have qualified under the Massachusetts method, which is using their own state data. This is the ATSDR, cumulative impact method that came out not so long ago, I think in 2022. This one actually shows that there's burdens in the facility, and it's being driven by proximity to Superfund sites, a little bit by linguistic ability, but instead of looking at the 80th percentile, these guys go down to the 75th percentile, and this facility is like right on the edge. So to me, it's very interesting. They're looking at health data as being slightly out of whack with diabetes, high blood pressure, and asthma. I saw on EJ's screen, it wasn't showing the census tract as being above normal for those criteria. So I found that interesting. It's the difference between 75% and 80th percentile. This is the DENREC viewer. I guess that was viewer 5. I'm going to quickly go through what I think EPA wants if they're pushing for an EJ analysis. And I base this off of a recent Hawaii environmental assessment and what EPA said they wanted. They want you to think about what kind of populations exist within the project area and explain why there's not going to be a disproportionate and adverse impacts to minority and low-income populations. And by the way, I failed to mention tribal populations this entire time. It's not a huge issue in Pennsylvania, but that's a whole separate and a very important issue. And they want you to talk about what public participation you're going to use and how you're going to coordinate. There's a big guidance document, very hard to follow, called Promising Practices for EJ Methodologies and NEPA Reviews for May of 2016. There's another guidance, by the way, for how you do it under regulatory practice and developing regulations. If you're in that space, I think that's from 2015. Guidance came out last year, or I think late last year or early this year, on EJ methodologies for air permit reviews. So you want to get the latest guidance. You want to describe your area of impact, which may be different for different types of impacts. Yeah, they want you to provide your source of demographic information. They push EJ screen. They want you, if you're going to have disproportionate impacts or regardless adverse impacts, to explain your mitigation measures, give opportunity for public impact on design, especially in low-income or minority areas, document what your process is for political involvement. And then we get into the green stuff. Can you construct with low-emission vehicles? Can you use alt fuels? Can you use green tech? Great story on anaerobic digesters, of course. Can you show the air quality benefits, the reduced adverse health effects? Can you identify what kind of mitigation you're going to have for public facilities, schools, daycare facilities, hospitals, senior centers? Some more ideas on what I think one of these permit applicants can do to address EJ when it's appropriate. Figure out what kind of corporate image you want and make sure if you're a bigger company, how you handle that issue nationally. Get your team together. Figure out what your state regulator wants. Get the support of government affairs. But if your state regulator doesn't want to address EJ, you may not want to run a contradictory purposes to them, or you may want to explain why you want to, but there should be alignment there. You may want to think about strategies to avoid EJ if you're EJ fearful. You can design below traffic study thresholds. You can have a minor source of air pollution instead of a major source. You can electrify instead of burning fossil fuels. Emphasize the benefits, probably one of the most important things, the economic and social and environmental benefits. If you have to do an environmental justice impact assessment, do it, but maybe you just want to do one anyway to get ahead of the issue with the press. And think about all those different stakeholder groups and whether they're cumulative impacts. It's not just these mappers. You have to kind of do windshield tours and other stuff. Involve the community, have meetings, do surveys, do outreach. Think about, doing this at the time of zoning when it's most important, or permitting. And then I would just say, as Michael said, build relationships, keep rinsing, keep repeating that. Think about additional mitigation strategies. When you hear from the regulators in the communities, check this census data closely. It's very messy, lots of mistakes. Learn arguments about the limitations of and problems with each database. Imitate the government's responses to EJ questions when they're giving grants or they're doing federal facility work. And of course, hire more lawyers and consultants. Other things you can do: hire local labor, hire local materials, contract with diverse suppliers, provide direct compensation, maybe fund an asthma center. You know, look at your construction plan with the community, give them notification about when they're going to get disturbed, increase urban tree canopy. Maybe you can buy offsets for your construction impacts with GHGs, adapt and reuse vacant lots for green infrastructure. And then all those climate risk measures that are out there where you can create more resilient and, you know, emergency sort of infrastructure. Do that, you know, make your projections realistic with regard to, you know, runoff and things like that. I'm going to stop so that there's time for questions. There's a lot of slides at the end of this that go through other state laws, New York. I'll talk, the slides contain the latest on cumulative impacts from EPA's Office of Research Development, if you're trying to figure out how to do that. I talk about the Maryland law, and I give an example with a recycler, and I give the New Jersey thresholds. And with that, I will turn it back to Wayne to moderate questions.
Okay, wow. Two great presentations, a lot of information. You know, Eli and I talked about possibly doing a part 2 of this. I think there's enough information and content here that we could maybe do that. And just so you know, I know that the NRC does have a Justice, Equity, Diversity, and Inclusiveness Council. So they have a person, you know, that chairs that who probably could provide a lot of input. I know that, you know, we talked a lot about East Coast states, so I'm sure there's a lot going out on the West Coast and even in the Central United States. So there's still a lot out there to talk about. So you know, it's time for some questions. So if you do have a question or comment, please enter them using the Q&A feature on your screen. And so this goes back, I think, to the first presentation from Michael's, and I think it might have been clarified already in the presentations. It's mentioning battery recycling facilities, carpet recycling, mattress recycling, solar panel recycling. How would all of these be regarded?
That's a good question. I think ultimately, when it's going to come down to the tonnage that is received by the recycling facility, as to whether or not it would potentially fall under the EJ rule, at least from a New Jersey perspective. I think it would come down to tonnage, and I think the 100-ton-day number for some of the facility types that you mentioned there would probably be a difficult number to exceed.
Mm-hmm.
There are states that are using 25 tons as a threshold. I think Connecticut is 25 tons, and I know there's another one. And I think that the other factor to consider for some of the other states is in states that are making a distinction between recycling and waste management or don't require permitting of all recycling facilities, sometimes they're looking at how much processing occurs at the facility. So I think it's more likely to trigger at something like plastics recycling than it might for other recycling processes that maybe just involve more shaping and sorting. That's my Pennsylvania bias.
Okay. So how many states have EJ laws or rules? And for the ones that don't, how does one, you know, file an EJ claim? Do they go default to the federal rules and guidance, or how does that work process wise?
So,
Go ahead,
Mike, do you want to go first?
I have a more limited scope, so you go ahead, and I'll expand if as necessary.
Yeah, I think the principal tool for making environmental justice complaints would be the Title VI law, and they would file a complaint with EPA, and it's supposed to be received within 180 days, and they're complaining that the state's process on that permit application or with regard to that program is discriminatory, and it's causing disparate impacts. And then an outfit called ECRCO investigates the state agency. And what's been happening since 2016 is they've been beating them up on not having good processes, not as much on the substantive EJ of fairly distributed burdens, but do you have a grievance process? Did you give proper notice? On the state level, if the law, the EJ law is not, if there's not an EJ, I don't know how many states have EJ laws, because basically there's multiple states that have public participation laws. There's some that have these siting laws. I would say it's about 4 right now, but it doesn't cover most of these facilities. It's New Jersey, Connecticut. It's mostly these East Coast ones, New Jersey, Connecticut, and New York now are covering them more directly, but you could file an administrative appeal with the state agency, or you could try to file a 1983 civil rights claim in federal court. Those are the basic avenues.
I think New Jersey may be first in with the actual EJ regulation. California has had stuff on the books in some sense for some time, but I don't think it's technically EJ regulation. I could certainly be wrong with that, so on that. The other piece I wanted to say was, even though certain states don't have, or even though most states don't have an EJ regulation, what we've seen is EPA has been submitting comments on certain applications to some of those states, some of the states without regulation, and putting in EJ comments and making recommendations on how to proceed from an EJ perspective. But in many cases, that still comes down to what the state has in their on their books from an EJ law perspective, EJ regulation perspective, and some of them take what EPA says and proceed. Some of them kind of just ignore what EPA says relative to certain permits.
Yeah, I agree with that 100%.
Okay. Yeah, there's a comment here from a person from DEP, the Pennsylvania DEP, that he's working on Covanta right now, which is a waste to energy facility. And if there are any concerns in Pennsylvania, they can email him at the Environmental Justice on the DEP. If everybody needs that, I can get that information to them. As far as in New Jersey, I'm thinking of, a recycling facility versus a landfill, for example. It would seem that you're actually mitigating pollution and mitigating the burden to the EJ community. So to me, I don't see there's any kind of point system built in or some kind of credit built in for a recycling facility versus for taking materials out of a landfill and reducing the burden.
Go ahead, Wayne.
I was just going to say, is that accounted for somehow? I guess in the report you could mention that, but how is that addressed?
So that's exactly it. That's a huge concern, and that's a huge concern of the recycling industry, whether it's typical household commodities or scrap industry or otherwise. That is one of the biggest concerns is taking, giving credit for, acknowledging the benefits of recycling, and those benefits are both on a local level and then obviously on a larger level as well. Those benefits can be seen, and so that's something that going forward we want to make sure is considered and that is recognized on a go forward basis. So good information on your part, Wayne, and something that's critical.
Yeah, and also the economic benefit of recycling, downstream of the recovery process, the interim processing and the manufacturing of a new product, just the climate benefits, the economic benefits. There's such a large benefit there in my mind, not just cans and bottles, but organics and food and so forth.
Sure, no, without a doubt, all great points and all something that from an industry perspective, we need to make sure that we work closely with not just the regulators, but also with the communities to discuss those important aspects.
Wayne, the only thing I'll say to kind of like round out the discussion and not take the position of industry at this point is to say, Number one, first of all, I completely related to your comment, and that was my initial reaction when I first started noticing recycling facilities getting listed on trigger permit lists. But read David Pelham's Garbage Wars, and he explains why it's recycling too, and why it's about worker safety and civil rights and the politics in Chicago and everything else. I'm not saying I agree with it. I just want to explain it can round out your understanding of where community advocates may get upset with particular facilities or particular processes.
Yep, and I think it's a lot of it's the industry needs to make sure the public understands what a compost site does or an AD facility does. A lot of times when these things are proposed, the public right away just says, I don't want this. It can't be good for the environment. So I think they need to do a better job at explaining, the benefits of these facilities.
Agreed.
So yeah. Like we said before, I think there's room here for a part two. There's a comment here that there's a lot of information to digest. I mean, Eli's research alone, I mean, that could be a doctoral dissertation, I think. It's unbelievable. So maybe he can present his thesis next time. But anyway, and also there's a suggestion of case studies. I think maybe the next one we could do some case studies in this. So just keep that in mind. So I think we're out of time. So I think we're gonna shut it down here. So again, thank you, Eli and Michael, for this great resource of information. Just like I said, is a lot. So something we don't talk about a lot, but I think we need to do more of this. So, all right. Okay. So, yep. So again, this webinar, like all the webinars in the series, has been recorded, will be made available via YouTube links on both National Recycling Coalition and Market Center websites. Thanks again for joining us. And we hope you'll join us for future webinars. Please visit our websites for scheduled updates. Thanks again, guys, and have a great day.
Thank you.
Bye-bye.